Welcome friends, this is the part 2 of the video on fundamental rights. For the part 1, please click here on the left hand corner of the screen if you want to watch it before. In this part, we are going to cover the right to equality, which is covered from Article 14 to 18. Article 14 provides equality before law and equal protection of laws. Article 15 provides prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth. Article 16 provides equality of opportunities in matters of public employment. Article 17 abolishes untouchability and prohibits its practices. Article 18 abolishes titles. Remember, these articles of fundamental rights, that is right to equality, was included by our founding fathers to remove the inherent inequalities that were existing at the time of independence, which is still existing now also. For example, Indian society has been divided into different strata based on ritual purity and social status. Historically, Indian society is divided into Chaturvarna, that is a Brahmin at the top, Kshatriya, Vaishya, and Shudra, and these were accorded different privileges based on their social status in the society. So Brahmins were treated as premium citizens and Shudras were treated as second-class citizens before independence. And also during medieval times, that is Mughal period, the Persian nobles were treated as superior to the tough common men. And also during British period, Europeans were treated as superior when compared to the Indians. And also landed aristocracy, zamindars and talukdars were treated superior and were given various extra privileges when compared to the common citizens. And also during those times, social malpractices like untouchability were practiced. And also some of the privileged classes were given opportunities in public employment. For example, in Mughal period, Persians were given posts in the administration of the country. And during the British period, Europeans were occupying the key positions, that is Indian civil services, throughout the imperial rule. So in order to remove all these inequalities and to treat all the citizens as equal, this right to equality has been included under fundamental rights. When I'm going to explain each and every article from Article 14 to 18, we are coming to know about the importance of this and the remedy that has been recommended by our constitution makers and its importance. The first thing is Article 14, equality before law and equal protection of laws. Article 14 says that states shall not deny to any person equality before law or equal protection of law within the territory of India. This is extended to all the citizens as well as the foreigners. And here the word person include legal person. As I mentioned earlier, legal persons include statutory corporations, companies, registered societies, or any other type of legal persons. Here the concept of equality before law came from British origin and equal protection of laws came from American Constitution. The term equality before law means absence of any special privileges in favor of any person and equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and no person is above law. Everybody is equal and below the law. A minister, an MLA, an MP will be treated same as a peon in a government organization or a coolie before a court of law. And this concept of equality before law was given by the British jurist A.V. Dicey. His concept is very important. His concept has three element aspects. The first thing is he propounds absence of arbitrary power. That is, no person can be punished except the breach of law. Nobody should be punished for no reason. And second concept is equality before law and equal subjection of all the citizens, whether they are rich or poor, or official or non-official, or so-called high caste or low caste, to the ordinary law of the land administered by ordinary law courts. And third concept he gave was primacy of the rights of the individual, means constitution was created as a result of the rights of the individual. The Indian system included the first 2 points, whereas the third point was not applicable to Indian system because Constitution of India provides rights to the individuals and not the individual is the masters of the Constitution. So this only third concept is not applicable to Indian condition. And Supreme Court in various judgments held that rule of law is basic feature and that cannot be amended. There are some exceptions given in the Constitution itself where the concept of equality before law will not apply. And these are Article 361 provides that President and governors enjoy the immunities, the following immunities. The first immunity is president or governor is not answerable to any court for the exercise and performance of the powers and duties of his office, because these posts were nominal. They are not real head of the government. All the real decisions were carried out by the cabinet in the name of the governor and the president. So this immunity is given to the president and governor. And second immunity is no criminal proceedings shall be instituted or continued against the president or governor in any court during their terms of office. And this reaffirm and protects the dignity of the constitutional position, because some frivolous cases may be filed against the governor or president to defame his stature. And third point is no process for arrest or imprisonment of the president or the governor shall be issued from any court during his term of office. President and governor cannot be arrested when they are in office. And fourth immunity is no civil proceeding shall be initiated against the president or the governor, but with the notification of 2 months, civil proceedings can be initiated. And these four immunities were covered under Article 361. Article 361A provides powers to any citizen to publish in any newspaper, radio, or television the proceedings that were carried out in either house of the parliament or in state legislature, and they cannot be prosecuted for publishing the legitimate proceedings of the houses of parliament. And this provision was given to reaffirm the right to information to the citizens. Article 105 provides that no member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in parliament or any committee thereof. Means whatever an MP tells within the parliament and whatever vote an MP casts within the parliament in the proceedings cannot be questioned by any of the courts. This is to protect a representative, that is an MP, from undue pressure from external sources, and also to encourage him to carry out lively discussions within the parliament about the problems of the people. And hence there is no restriction has been imposed on the MPs within the parliament. And the same provision is extended to member of legislature or assemblies, that is at the state level, under Article 194. And Article 31C provides an exception to the Article 14, that is equality before law, that is to implement the directive principles of state policies contained in Article 39B and 39C. If the government implements the provisions of 39B and 39C, they cannot be questioned as unconstitutional since it violates Article 14. There is some exception given in the Constitution itself to implement directive principles. And next immunity is the foreign sovereigns like ambassadors, diplomats, head of the states has diplomatic immunity, and they are treated as exceptions to the Article 14. The next article is Article 15, which provides prohibition of discrimination on certain grounds. Article 15 says that states shall not discriminate against any citizens on the grounds of only of religion, race, caste, sex, or place of birth. Here the two words are very important: discrimination and only. Here discrimination means to distinguish unfavorably from others, and the word only means only on the basis of these sections like religion, race, caste, sex, or place of birth, are not on any other grounds. And the Article 15B says that no citizen shall be discriminated, restricted on the grounds only of religion, race, caste, sex, or place of birth with regard to access to shops, public restaurants, hotels, and places of public importance. And B, the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly by state funds are dedicated to the use of general public. So as I was discussing earlier, these provisions were included to remove the inherent anomalies which were existing in the society at that time. At that time, the lower castes and untouchables were not allowed to the public places like shops, restaurants, hotels. And these restrictions were removed by the Constitution itself with the help of Article 15, and to extend the privileges to all the sections of the society equally. With this, the citizens has the fundamental right to protect his equality with others. And if it is violated, he can approach the Supreme Court or either High Court to restore his violated right. This is the importance of this article. And there are some exceptions provided to this article, like state is permitted to make special provisions for women and children. For example, reservation for women or free education to the children. States are free to provide such exemptions. And state is also allowed to make any special provisions for the advancement of any socially and educationally backward classes of citizens like SCs and STs. And third exception is state is empowered to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the SCs and STs regarding their admission to educational institutions, including private education institutions. State is empowered to provide reservations. And this third provision was added by 93rd Constitutional Amendment Act 2005 for extending 27% reservation for other backward classes in all central higher educational institutes like IITs and IIMs. In 2008, Supreme Court upheld the validity of this act, but put conditions that the creamy layer, that is the children from rich families, should be excluded while applying these provisions. Here the creamy layer refers to people belongs to these categories, like persons holding constitutional posts like president, vice presidents, judges of Supreme Court, High Court, or chairman and members of UPSC, State Public Service Commission, Central Election Commission, CAG, or Group A, Group B officials of the central government, public sector undertakings, banks, insurance organizations, or any business persons involved in trade and industry, or professions like doctors, lawyers, engineers, artists, authors, consultants, or persons in the rank of colonel and above in the army, and equal ranks in the navy and air forces, and those agricultures having above the certain limit of land. And these are all provisions of Article 15. The next article is Article 16. It provides equality of opportunity in public employment. Means everybody and every section of the society has the equal right to hold the public positions, public offices, and to enter public employment like government jobs. Article 16 says that no citizen can be discriminated against or be ineligible for any employment or office under the state on the grounds only of religion, caste, sex, descent, place of birth, or residence. But there are three exceptions provided in the Constitution for equality of opportunity in public employment. The first exception is Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory. For example, Article 371J provides special reservation for Hyderabad Karnataka area, which is backward area in Karnataka. And second exemption is the state can provide for reservation of appointment or posts in favor of any backward classes that is not adequately represented in the state service. State can provide reservation for any backward classes, which is still providing. Various states, all the states are following this provision, this exception. And third exception is related to religious matters. And religious institutions are allowed to employ the persons from the same religion and excluding the person from other religions. This is to uphold the right to profess, practice, and propagate its own religion, given in Article 25. Article 17 provides for abolition of untouchability in any form. And Article 17 says the enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. For this, the Parliament enacted Untouchability Offences Act 1955, and in 1970s it has been amended to give more teeth to the enforcement agencies to protect the weaker sections more efficiently. But the word untouchability has not been defined in the Constitution. But importantly, the Mysore High Court provided the meaning of untouchability. It says that social disability is imposed on certain classes of persons by reason of their birth in certain castes. Means if a person born in an untouchable caste, even though he is very efficient, very talented, he is still be treated as untouchable, inferior, and was prevented to practice other professions apart from his own profession related to his caste. Like a chamar was forced to work with the shoes. In the previous centuries, he was not allowed to open the hotels or to join public services, hold public offices. So the worst thing in medieval India was that the castes were assigned the specific professions and they were allowed to practice their own professions. The POCR, that is Protection of Civil Rights Act 1955, declares that the following acts are offences. They are preventing any person from entering any place of public worship or from worshipping therein, justifying the act of untouchability on traditional, religious, historic grounds, denying access to any shop, hotel, or places of public entertainment, insulting a person belonging to SCs or STs on the grounds of untouchability, refusing to admit persons in hospitals, educational institutions, or hotels established for public benefit, like government-aided colleges, hospitals, and institutions of public character. And preaching untouchability is also an offense. So this is a reasonable restriction. Article 19 provides freedom of speech and expression, but the same article prohibits the preaching of untouchability. That's called reason of restriction. Remember the previous video. And the last article of the video, that is Article 18, abolishes titles and make 4 provisions in that regard. It prohibits the state from conferring any titles except military and academic distinctions. Military like Paramavir Chakra, academic like doctor, professor. From this explanation, it is clear that the ascribed titles like Maharaja, Rajadhiraja, Raj Bahadur, Zamindar, Rai Sahib, Diwan, which were confirmed by colonial governments and princely states, were abolished. And the main aim of this Article 18 is to bring equality between the people. In case of social status, there are 2 statuses. One is ascriptive status. Another one is achievement status. In ascriptive status, the status comes with the birth. If a person born in a noble family, he will be respected, irrespective of his talent, intelligence, or his achievement. And the second social status is achievement status. Here, the person has to achieve something in order to gain the respect from the society. So, Article 18 abolishes ascriptive status. So, it treats all the citizens as equal, and there is no titles if you born in any of the so-called superior families. So, in a democratic India, everybody has to work hard to gain better social status. He has to contribute to the country immensely in order to gain Bharata Ratna. This is the meaning and summary of this Article 18. So this is the end of this video on right to equality. In the next part, it's part 3, I'm going to cover right to freedom. That's Article 19 to 22, which is very important. And we can include these concepts in any of the writings in general studies. We can fetch more marks.